Thanks, Liz. It's Marie here, everyone, again. So just moving on to my section of the webinar. So we'd been asked a couple of times, oh crikey, what's all this about holiday pay? I've got lots of clients who were panic-stricken actually and doing financial forecasts going forward, trying to factor in amounts going back to 1998 for potential liability for unpaid holiday pay. And it was a bit of a trauma actually for a lot of people. I think basically at one point, if we can have a look at the next slide, there was a lot of hype. So today we're going to be looking at basically the hype. So what was the problem, the law, the various cases and where we are now. I think, I mean, everybody knows me by now. I think if you're new to the webinars, then I'm an employment lawyer. Set up my own firm about 3 weeks ago, which was very exciting. And we're Consilia Legal, specialising in employment, and the other side of it is family, but with an overarching emphasis on mediation, so civil, workplace, and family. I've been practicing employment law for 13 years, and I'm also a part-time lecturer at the College of Law. So I get a lot of feedback from a lot of different areas, and particularly the students are interested in this as well. So basically, if we look at the hype first, the hype prior to Bear Scotland was insolvency for some employers, backdated holiday pay claims back to 1998 potentially, task forces being set up by the government, and as I say at the bottom, unlimited backdated claims potentially at one point. I saw on the BBC News, which I thought was a bit of an over-exaggeration really, and so it has turned out to be. So if you are having an absolute panic about it, my advice to you, if you're going to log off in the first 5 minutes of the webinar or you're off to eat your lunch, is please don't. Look at it carefully, but don't have a breakdown over it. So if we go back to the law first of all then, I just wanted to refresh because there's a lot of confusion. People read the cases and you might be well up on the law and know everything about the European Working Time Directive and then the Working Time Regulations, but I know it has caused confusion for some of my clients and I just wanted to clarify it now. So forgive me if I'm telling you something you already know. So basically, what about holiday entitlement? Well, holiday entitlement, we get edicts from Europe about these things, and Europe have the European Working Time Directive, and that basically is a health and safety driven directive which wants to afford employees and workers, because remember this is workers as well. I won't go into the difference between an employee and a worker for now, but affects workers, and it gives them rest from work, and that's the key to it. So basically, it dictates that workers get rest from work, and one of the types of rest they get under the Working Time Directive, so the European stance, is 4 weeks annual leave. So for a full-time worker, that's 20 days. The whole focus is rest and recuperation, and that was emphasised recently in another holiday pay, sick pay case, Lana. Now that was in Leeds actually, where the tribunals and the European courts basically came to the conclusion that, you know, if you're sick, you can't be taking your holiday because, again, the key focus is you're either sick or you're having holiday and it's rest and recuperation. So the focus is rest. Now, if you work for an emanation of the state, you can rely directly on the Working Time Directive. So if you work for a public body, basically, then you don't have to go any further. You've got the right to that 4 weeks. You can rely directly on Article 7 of the Working Time Directive. However, for private employers, and the way that we implement European law in this country is by way of the Working Time Regulations. So if you're a private employer, then you're governed by the way that we have implemented the Working Time Directive, which is the Working Time Regulations, and in particular Regulation 13. Now, it used to be that in the UK we had 20 days holiday, and that could include bank holidays, because obviously going back to the Working Time Directive, you were allowed 4 weeks. It changed quite recently, I say quite recently, it seems like it to me, to 5.6 weeks. So we get the 20 days in this country now, plus the 8 days, which is additional leave. Now that becomes relevant later on. So now if you're a full-time worker in the UK under the Working Time Regulations, you're entitled to 28 days leave. Right, I'll take a deep breath there. So, obviously that right is automatic. You don't require a length of service to qualify for your holidays, but it can be prorated if you start and finish work partway through a holiday year. In addition to the leave that we have under the Working Time Directive and the Working Time Regulations, you may also in practice deal with additional contractual leave. And I didn't put that on the slide because I don't know whether some of you offer it or not. I'm sure you do. But if it's over and above the 28 days, then it's what I would call contractual leave. Okay, so moving forward then from that, we've got the number of days. I thought it would be sensible to look at pay before we go to where we are next. So under the working time regulations, we're advised in that legislation that a worker is entitled to a week's pay for each week of leave. Okay, fine, sounds perfectly normal. A week's pay is calculated by reference to or is discussed in the Employment Rights Act. And there's two types of calculation here. So first of all, under Section 221, this relates to workers who have normal working hours. And basically, Section 221 says, if a worker has normal working hours, then a week's pay is calculated by reference to those hours. Again, not particularly helpful, but it doesn't include overtime, bonuses, commissions, etc. So it's whatever the normal working hours are for that week, that would be the amount of holiday pay in the event that the worker took holiday. Okay, by contrast then, we've got Section 224 of the Employment Rights Act, and this applies to workers with no normal working hours. So, for example, in Section 221, I might employ somebody to work 40 hours a week for me, and those are the normal working hours, and I might have a contract that says that. So their holiday pay would be calculated by reference to those hours, full stop, nothing else. Say I employed someone else, however, and they have no normal working hours, so I might call on them 3 days a week one week, 2 days a week the next, no days the following week. So a sort of your casual workers, I suppose. You've probably got other examples that you could give. In the event that there's no normal working hours, it's slightly different under 224. So a week's pay for those people is calculated as an average of all remuneration paid in the past 12 weeks, so in the 12 weeks preceding the holiday. And in that case, then, it could include bonuses and commissions. So it's an average of the last 12 weeks. So the focus really around holiday pay has been about what is a week's pay and is it fair? Okay. So the way I saw it when I got to the end of this section was, look, you're much better off potentially having no normal working hours than you are having normal working hours, which seems perverse. But anyway, I'm sure other people agreed with me, and that's why we've had some recent debate and discussions about it. So I'm not going to go into all the detail of all the cases. I'm sure you've read the facts in the press, but just looking firstly then at the European decisions in this area. So because we've got this anomaly, and obviously there's an issue, because if the idea of the working time regulations and the working time directive is that people take rest from work. The problem with the way that holiday pay is calculated, particularly for those with normal working hours, and to some extent it's unsatisfactory under no normal working hours, means that, for example, if an individual is at work, he will be better off, he or she will be better off than if they take annual leave. And the concern is that people shouldn't be concerned to take annual leave. They shouldn't be disadvantaged by taking the leave. So, for example, by losing a commission or a bonus or, you know, anything else that might be included, which I'll come on to in a second. So this was first taken up in Europe in the British Airways case. So we're looking at pilots. It was taken up under the Aviation Directive, actually, but latterly the same issue was applied to the Working Time Directive, so I'm referring to it anyway. And the pilots challenged the pay here. And they were losing out when they took holidays because they were losing out on on commissions over and above normal salary. And the way that Europe addressed it was to say, okay, well, We don't think that the pay during holidays for these people should be limited to basic pay. And I'm going to move away from a week's pay, and I'm going to talk about what would have been the normal remuneration. Okay? And when it said what is normal remuneration when we're calculating holiday pay, it went a bit further and it said, okay, we think that when we're calculating holiday pay for these pilots, normal remuneration, it should be taken to include any pay or remuneration which is linked intrinsically to the performance of their contractual duties. So this intrinsic link to the performance of contractual duties. So that's the first thing. And secondly, any other payments relating to their professional or personal status. So that might be, for example, other payments pertaining to length of service or other payments that are made to them by way of the fact that they've got professional qualifications. I can't think of any other examples. There's probably loads in the case, but so it sort of took a different approach. Instead of saying, look, a week's pay is a week's pay and that's what you get, it said, look, let's look, actually, make it fairer. Let's look at what normal pay is. What should you get? Let's not deter you from taking your holidays. Okay, from that case, we moved on to Locke and British Gas. And in this case, the issue was commission. So the issue was that, again, a disadvantage if taking holiday in the fact that commission was then not paid. So actually the individuals were worse off for taking holiday and then not actually compensated properly. So the focus here was on commission. It looked at the working time directive and they did decide again, look, if this commission is not paid, it's a financial disadvantage and it's a disincentive to taking the leave. So if we're looking at what should be included in pay, we think again it should be normal remuneration and potentially therefore, in fact, actually commissions should be included, some kinds. Right, so I've got some questions. I'm just going to have a quick look through these now.